own whims and caprice, he formulates what he calls guidelines aimed at achieving an end that is known to himself. So that in the recent past we have seen him develop guidelines that are aimed at controlling investigations and any action that the police or policemen will take as against any person who has been suspected or is being investigated for being involved in terrorism acts. So that it is now a guideline developed by his office that when the policemen are investigating anybody who is suspected to be involved or who is supposed to conduct any terrorism act, he must be informed prior to his arrest or prior to the investigations being taken. Number one, we do not know why or for what purpose Mr. Noordin Haji wants the investigating agencies to report to him before investigations are done on people who are involved in terrorism. Secondly, we do not know for what purpose he will want to be involved in the investigations. It should be recalled that the office of the DPP is a creature of the Constitution. His powers are clearly enumerated in Article 157 of the Constitution. We do not know why he will go to the extent of arrogating to himself powers that are given to the investigating agencies, particularly when we read Article 245 of the Constitution. So that what we knew previously, because previously prosecution was conducted by police officers, but the engineers or the drafters of our Constitution thought that in order for us to have very objective prosecutions, we should not have a situation where the DPP or the public prosecutor is involved in investigations, because entirely what prosecution should achieve is a fair process. And to the extent that Mr. Noordin Haji will want to be involved in investigations, we read a lot of mischief. We see that he wants to be, there is something that he wants to achieve other than what he was mandated or is mandated to do. Kwa kifupi tunasema ya kwamba kuna madai yaliyoletwa kotini ya kwamba bwana Noordin Haji anajaribu kujihusisha na kujihusisha na uchunguzi ambao unafanywa na mapolisi wetu, na kwa kauli moja jamaa anaitwa Memba Ocharo ambaye ameelekea kotini anasema ya kwamba jambo hilo ni jambo ambalo linakiuka sheria. Ni jambo la pili ambalo linaonyesha ya kwamba bwana Noordin Haji pengine anatamama na asimio ya kufanya mambo kinyume na katiba ili aweze pengine kufanikisha ajenda fulani ambayo sisi kama wananchi hatuijui. Asanteni.
Kiongezea yale yangu amesema ni kwamba tumo kotini kwa swala la jinsi ya kutatua swala la ugaidi, terrorism. Wale magaidi wa terrorism, watu ambao hawafuati sheria zozote. Wakenya wanakumbuka yaliyotendeka wakati magaidi walipolipua ile ambayo ilikuwa inaitwa American Embassy katika taifa la Kenya. Wakenya zaidi ya 200 waliangamia, wengine wana majeraha mpaka leo. Wakenya bado wanakumbuka yaliyokuwa yakitendeka wakati wa magaidi walipovamia Garissa University. Zaidi ya wanafunzi 300 na kadhalika waliaga dunia na Wakenya wengi kupoteza fahamu, wengine majeraha walionayo mpaka sasa. Wakenya bado wanakumbuka yaliyotendeka pale Westgate ambapo magaidi walivamia na kuharibu mali na kuua Wakenya wengi na raia wa nchi za ng'ambo waliokuwa huko. Mwisho, Wakenya wanakumbuka yaliyotendeka juzi katika mkahawa hoteli maarufu ya Dusit ambapo mali na maisha yalipotea. Je, yale yaliyofanywa na kiongozi wa mashtaka ni kwamba sasa amesema kwamba kabla ya kumshika yule ambaye ni gaidi lazima polisi wamjulishe yule jamaa, yule ambaye ni DPP kwamba tumemwona yule gaidi, na yule gaidi anapanga kupiga bomu katika hii hoteli. Utatukubalia tumkamate ama tusimkamate? Gaidi anapoingia huchukua sekundi, hata sio dakika moja, kutekeleza aliyokuwa naye. Sasa tunaambiwa lazima kiongozi wa mashtaka atafutwe, apewe ushahidi kabla ya kumshika ule gaidi. Basi hayo ndio mambo tunauliza, nini madhumuni yake hasa ya kufanya polisi wamngojee aweze kupeana idhini, na kumbuka kwamba zaidi ya makesi 5,000 ziko kwenye ofisi zake ambazo mpaka sasa hajaziidhinisha. Polisi wanangojea idhinisho lake ndiposa aweze kushtaki. Kwa hivyo hayo ndio mambo tumezungumzia. Mahakama imetusikiza na imeona kwamba swala tuliloleta ni swala zito kwelikweli, na imesema kwamba tutasikizwa tarehe 10 mwezi wa 5. Kwa hivyo ni mambo ya dharura sana, sababu tisho la ugaidi ni tisho lisilokuwa tisho la Kenya peke yake, ni ulimwengu mzima. In the English language, we have gone to court simply to challenge the directives of the Director of Public Prosecution that he must have proof on matters terrorism before the police can arrest, before the police can engage in combat with the terrorist. I have enumerated, for examples, one, when the terrorist attacked the American embassy, more than 200 Kenyans died and several foreigners plus property was lost and injuries today, and the trauma on those who are affected are great. 2, we had a similar attack at Garissa University and several students were killed, and that is still in the memory of Kenyans. 3rd, we had a similar attack at Westgate, and therefore every Kenyan knows what happened at Westgate. Lastly, the attack on Dusit was just the other day. So the question we have posed to the court is, under the guidelines, the police, the GSU, and the military, upon detection of an attack of terrorism, now the guidelines are they must go and seek authority from the Director of Public Prosecution that we have seen a terrorist walking like Mr. Omari somewhere with guns and grenades. Can we arrest? What we are telling the court is that terrorism is incidences that act in seconds. Any divulging of information of what the police have is not in the best interest of Kenyans. So we are seeking the court's intervention to stop Noordin Haji from becoming a police officer. That every action the police must do, he must be informed for him to make a decision. Are Kenyans not being exposed with such a bureaucratic red tape in dealing with the questions of terrorism? Is that practice anywhere in the whole world? It is not anywhere in the whole world. Every country's major concern is how to avert terrorism. It is an overt exercise, and the terrorists never give. Not as a simple example, a terrorist is found to have grenades inside an aeroplane. Will the police wait not to act until they write a letter seeking authority to arrest a terrorist who is already in a hotel or inside a KQ flight? It is practically not possible in the direction the state, the DPP has taken. That is why we have gone to court, that this appetite of amassing power in that office is not in the interest of citizens of this country. We will not want a repeat of Westgate. We will not want a repeat of Dusit. We will not want a repeat of the US embassy bombing at the expense of an officer who is interested to bring bureaucracy where his job and definition under Article 157 is purely to prosecute.